Let us discuss the next question. This is a question from 2020. Which of the following categories of fundamental rights incorporate protection against untouchability as a form of discrimination? Right to exploitation, right to freedom, right to constitutional remedies, right to equality. Which of the following rights has a protection against untouchability? That is the main purpose of the question. Now let us look at the provisions. If you recall, in the articles 14 to 18, we have the right to equality, where article 14 talks about equality before the law, then 15 talks about prohibition on discrimination based on the grounds of religion, race, caste, etc. And 16 talks about the opportunities for public employment, and 17 talks about untouchability, and 18 talks about abolition of articles. Now if you look at untouchability, that is Article 17 more closely, what does the provisions of the Constitution and the various Supreme Court judgments talk about? The Article 17 very clearly says that it is about the abolition of untouchability. Now, untouchability is abolished and its practice is forbidden in any form, and it is the responsibility of the state to take action even against the private individuals who practice untouchability, and for that the state has to create some laws. For that very reason, the government has created earlier it was the Untouchability Offences Act of 1955, and later this was renamed in 1976 as Protection of Civil Rights Act. And this article is very important in the sense that it not only helps and is part of a right to equality, it also helps in providing the social justice. And it is also to make sure that untouchability is avoided, not just the Civil Protection of Civil Rights Act, even in the same energy, the government has constituted the SC/ST Prevention of Atrocities Act of 1989. But nowhere in the Constitution or in any law, the word untouchability is defined. So it is not defined in the Constitution. So ultimately, in the Devarajaya versus Padmana case, the Madras High Court defines untouchability. The court says that when we say untouchability, it's not in the literal grammatical sense. When we say untouchability in this context, it is the practice that was there historically in the country, that it was the practice which was practiced against the certain section of the people, certain class of people, and the discrimination that was done on them based on the caste that they were born into. So that is the practice of untouchability, and this is what the court is trying to define. And the court also clearly says that it does not cover social boycott of very few individuals or their exclusion from the religious services. The court very clearly in a different case says that it is the responsibility of the state to action immediately, even against the private individuals who have violated this article. So now let us move on. And regarding the other options in the question, there was right against exploitation. We know that right against exploitation is defined in Article 23 and 24. 23 talks about prohibition of trafficking in human beings and forced labor, and 24 talks about the prohibition of employment of children below certain age in the various hazardous factories. And 19 to 21 talks about freedom. Article 19 talks about the various different types of 6 freedoms. Then 20 talks about the protection in respect of conviction for certain offenses, and Article 21 finally talks about the protection of life and personal liberty. Article 32 deals with the constitutional remedies. So finally coming back, if you go to the question, which of the following categories of fundamental rights incorporate protection against untouchability? So very clearly we know that Article 17 comes under the right to equality. So D is the correct answer here. Let us discuss the next question. This is from the year 2021. A legislation which confers on the executive or the administrative authority an unguided and uncontrolled discretionary powers in the matter of application of the laws violate which of the following articles of the Constitution? The question is saying, if we give uncontrolled and unguided discretionary powers to the executive. Which of the following articles will be violated? Article 14, Article 28, Article 32 and Article 44. For that we need to recall what are there in the particular articles. If you look at the Article 44, similar 44. The trick here is Uniform Civil Code. Remember CC and 44. So Article 44 contains the provisions about the Uniform Civil Code, and the Article 32, it contains the provisions about the right to constitutional remedies. And Article 28 has provisions with respect to the freedom of religion, and specifically the freedom from attending religious instructions in certain educational institution managed by the government funds. And Article 14 to 18 has the provisions with respect to the right to equality, and specifically we have the equality before the law and the equal protection of the law in the Article 14. Now the question is saying us, if you give uncontrolled and discretionary powers to the executive when it comes to the application of the law, which of the following articles will be violated? If you look at the provisions of Article 14, what is there? Equality before the law and equal protection of the law. Ultimately, equality before the law, it means that whoever you are, it doesn't matter, you are treated equally in front of the eyes of the law. So there is equal application of the laws. But if someone is having the discretionary powers whether to implement the law fairly or not, and if they are given the power to not implement the laws fairly, what will happen in such a case? In such a case, they will not equally apply the law and people will be discriminated. So it will basically try to violate the Article 14. So which of the following articles will be violated here? It will be the Article 14, equality before the law and equal protection of the law. Let's look at the in-depth explanation now. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the law within the territory of India. And here, when we say any person, it can be a citizen, it can be a foreigner, or it can be a legal entity like a company or partnership. The very concept of equality before the law, it is inspired and derived from the concept of rule of law, and the concept of rule of law that was given by A.V. Dicey. What does rule of law say? Rule of law, it means that the state has to be governed according to the laws and provisions which are there and not according to the whims and fancies of the people who are ruling. Earlier it used to be the kings, now it is the government. The state and the country, it should not be run according to the arbitrary actions of the ruler or the government, not according to the whims and fancies of the person who is ruling, but according to the law. That is why it means that rule of law. So when the application with respect to the rule of law and the equality before the law is violated, that will be violated only when the rulers have the discretionary powers when it comes to the application of law. So option A, Article 14 is the correct answer here.